Assemblymember Stephen Bradford. The Federal Aviation Administration has been mandated to integrate unmanned aerial systems into the national airspace by 2015. The FAA predicts that 30,000 drones will be in the air in less than 20 years. The potential for civilian and commercial use of drones will be tremendous, but like any other technologically advanced tool, it can also be susceptible to abuse without oversight and rules. This bill establishes a number of restrictions on governmental and private use of drones. First, law enforcement will only be permitted to use drones if there is a reasonable expectation of criminal activity and has obtained a warrant based on probable cause. There are exceptions provided in emergency situations such as hostage crisis, imminent threat to life, search and rescue operations. This bill also permits drones to be used by public agencies in circumstances where privacy concerns are not at hand, such as detecting oil spills, preventing forest fires, and aiding in traffic accident investigations. There are a number of provisions that provide added safeguards from potential abuse, such as a requirement that all data collected by drones must be destroyed within 10 days if that data is not used as part of a criminal investigation. This bill also will require that local public agencies only be allowed to purchase and use drones with the approval of the local legislative body upon the adoption of policies governing the use of drones. Lastly, this bill prohibits private persons and entities from using drones for the purpose of surveillance of another person without that person's consent. It's important to remember that the vast majority of uses of drones, especially by governmental agencies, have no privacy concerns. For example, CAL FIRE's use of drones for fire prevention purposes and the agricultural spraying of row crops these uses do not raise privacy concerns. The bill before you today is a culmination of many hours of meetings and discussions with the entire spectrum of stakeholders. I believe that this bill is on the right track, but I also fully expect more work to be done on this measure, as more than 30 other states are currently going through the same process, pursuing drone privacy regulations within their own jurisdictions. My staff has worked very closely with the ACLU. We've also worked very closely with law enforcement, constitutional lawyers, as well as other stakeholders, and are committed to work out amendments and continue to shape the bill into a better product. We both share the goal of putting together a bill that protects privacy rights for Californians. I have communicated with the ACLU my commitment to work on addressing their concerns that have been outlined for you in the committee analysis. Should the bill pass this committee, it is my commitment to this committee and this chairman that I will not move this bill forward through the second policy committee unless the ACLU has at least publicized its neutral position on the bill. If they do not, it is my commitment to this chair and this committee that I'll bring the bill back to this committee to further work on it. It's important that this bill continue to move forward at this time. It has been referred to policy committees, and the time is running out. Without a doubt, there are significant challenges when crafting legislation that is anticipating the integration of advanced technology that will continue to evolve in the future. But as many other states across the country are currently doing, we must, to the best of our abilities, put together rules and guidelines that are necessary for the protection of the rights of people who live in this state, and convey to them that we are cognizant of their concerns. I respectfully ask for your vote.
Thank you very, very much, Mr. Gorell. Are there any witnesses in support? Okay. Witnesses? No. Witnesses in opposition?
Mr. Chair, members, Aaron McGuire on behalf of the California State Sheriff's Association. At this time, we must respectfully oppose this measure for the reasons that are set forth out in our letter. For the most part, we just think that this measure is premature because there aren't any uses of unmanned aircraft right now that we're looking at in the state of California. We appreciate working with the author's office. We've had some very healthy discussions, but at this point, we don't see a distinction between utilizing helicopters and utilizing unmanned aircraft, and for those reasons, we're opposed. Thank you.
Any other witnesses in opposition? All right, seeing none. Any questions or comments from committee members? Mr. Moore and Ms. Melendez?
First of all, there's a big difference between a drone and a helicopter. You can't put a helicopter up over someone's house for half a day without them noticing. A drone can be up there a very long time. Small model airplane, you're not going to notice it. It is illegal surveillance. The second is they're saying there's no projected use of drones. Right now in Alameda County, the sheriff wants to procure drones. The Board of Supervisors has major objectives. Under the amendments proposed by the ACLU, which the author has accepted, that legislative body would be able to adopt protective standards. This is extremely important in my county. It is a very, very big problem. It is today. It is not next year. So I feel we have to move ahead. The ACLU had 7 amendments that they projected. One of them, exigent circumstances, is a little bit difficult to define, but my understanding is, Assemblymember Gorell, that you've accepted 6 out of those 7?
Yes, Assemblymember Burke. We've submitted to Reg Council, and I've put this before all the committee members, a list of their suggested changes to the bill that would get them to presumably a support position or a neutral position. And we've outlined our, with the specific language we submitted to Reg Council, allow them to start working with us to draft responses so that this is amenable to that organization.
All right. And then as I looked at, just looking at it this morning, I didn't see the letter from the ACLU until this morning, with 6 of those 7, I could see that they were fairly easy to agree to. The exigent circumstances question is more difficult. Exactly how you define that is going to be difficult, but you've agreed again to get the ACLU to a neutral or support position before the next committee. Mr. Chair, is it appropriate to ask the ACLU to say something at this point, should they wish to?
You read my mind.
All right, thank you.
What there is left of it.
Hi, Mr. Chair and members. Kim Hardy, Chief ACLU of California. Valerie Swollen-Barrow in our office actually negotiated with Mr. Gorell and Mr. Bradford, and I understand are continuing those negotiations, and I'm sure that ACLU of California is hopeful that we can reach some sort of compromise on the position. And so, you know, she's not here at the moment, but I think that was the understanding between the author and Ms. Swollen-Barrow. If you have any questions, I'd be happy to email them to her or track her down somewhere. So, thank you.
Yeah, my question is, where is she?
Yes.
It's an important issue.
I'm going.
Okay, Ms. Melendez.
Thank you, Mr. Chairman. Mr. Gorell, this does not apply to military use, right?
No, it's not intended to apply to military use. Certainly, this is for more commercialization and civil use of drones domestically.
So the standards and the restrictions that we're placing, or that you're placing on the use of these drones does not apply to the military. I just want to be clear on that.
No, it does not apply to the military. They have their own restrictions against using any kind of U.S. military force domestically. They have their own restrictions set, but we would need to amplify that because it already exists.
Okay, I just wanted to be clear on that. Well, it's a little concerning that there aren't any restrictions in place right now on the use of these drones. So I commend you for bringing this forward and making sure that we get ahead of the game. I understand and recognize the concern people have with the use of these drones. There's certainly some major privacy issues that have been raised, and none of us want to find out that a drone has been watching us in our backyard for the past 3 hours and we've been unaware. So there's definitely some privacy issues on it. It sounds like you've gotten that kind of squared away with all of the involved stakeholders. So I will offer you my support for this.
Okay, Ms.
Mr. Chairman. Assemblymember Gorell, I have two questions. One of them is it indicates that cities or local jurisdictions would have the ability to make tighter restrictions. Would that permit a city to ban the use of them, or what types of restrictions?
The bill expressly does not prohibit local communities from creating stricter guidelines if they choose to do so. This lays down just some really basic criteria and guidelines for their use throughout the state as a baseline. And that is, the intention there is to allow local control as best. We heard that back from local communities as they wanted to say this as well.
And then the second question was, with law enforcement, has this bill, if it moves forward, would there be the ability to maybe exempt bona fide criminal investigations from the 10-day purge? It seems like the 10 days is kind of restrictive. If you're dealing with a legitimate criminal investigation where all the other things were handled as far as warrants and the other restrictions.
It's a good question. Actually, the 10 days, in terms of the time before the law enforcement agency would have to destroy it, is a date that we worked out for the law enforcement. Originally it was 4 days, but we moved it to 10 days. And it makes sense to law enforcement. Most of the feedback we got was that they should have an idea of whether that information will be used within 10 days. And if they don't, they prefer to destroy it anyway, because otherwise it sits there and it becomes subject to the Freedom of Information Act by any Californian who would submit that kind of Freedom of Information Act. So the requirement to destroy it unless they use it benefits everybody, we think. And so, as a former deputy district attorney myself for 7 years, typically if you're conducting surveillance, whether you're going to be using or able to use that surveillance within a short period of time, it makes sense to destroy it because you'd be collecting information on things that are extraneous to the person, people, or compound or building that you're watching. And so the 10 days is something that I think I can understand law enforcement generally thinks is a reasonable deadline and date, and they are generally supportive.
That answers that question. And I think having restrictions on the use of these drones is a good step. There's a lot of uncertainty about them. A lot of people are concerned about them, which is a legitimate concern, and I will be supporting this bill. I think it's a good move in beginning that discussion about what types of restrictions we should have.
Thank you very much.
Thank you very much, Mr. Chair. Mr. Gorell, this issue, which is clearly likely be an emerging body of law dealing with overall privacy issues, just reminds me of experiences I've had working in and around the building with regard to a number of emerging issues, biotechnology and others, where the legislature realized that there hadn't, case law hadn't kind of established a direction, and nor had this legislature or legislatures around the country. And I think this issue falls in that category. And in keeping with that, I think we have a responsibility to craft a body of work that's both informed and thoughtful and deliberative. The fact that your bill appears to be a moving target with amendment language just shared with the committee today suggests to me that this bill isn't cooked. But from a broader perspective, Mr. Chair, it seems to me that informational hearings, perhaps in concert with judiciary and other appropriate policy committees, make sense to have the broader, thoughtful conversation around privacy issues, given new technologies. We haven't had that as an elected body, and I don't want us to put the cart before the horse. While it is a critical issue that we have to move on, I'm not saying sleep the issue, but I think that there are broader issues beyond just the drones dealing with technology that involve privacy issues around California residents across the board that we as a body need to think through and perhaps come up with a package of legislation that's informed through that process. So I'm going to stay off the bill today because I just don't get the sense that it's soup yet. I appreciate your commitment to bring it back to the committee, but I think we have a responsibility broader to the overall issue of privacy that we really need to deal with in a very thoughtful, proactive manner. So I'll be staying off today.
All right, is there any other comment? All right, seeing none, I have a...
Yes.
Can I make my comment? Sure. Mr. Gorell, you are of impeachable conduct, and I appreciate the outreach. We wouldn't often see that from other members, particularly to the ACLU. It's a very, very complicated issue, and I agree totally with Ms. Mitchell. I had offered you not to delay this, but to be more deliberative, to have an informational hearing, which I still think is appropriate. Here's what I'm going to do, because ACLU is not here, and again, it is no reflection on your deliberate and honorable manner in addressing this issue. So in my benevolence and in my sagacity, I know that this is going to go to local government, and you have a week. So I'm going to hold this item until next week to see if you can present something that's a little more cooked, that the ACLU is here, and perhaps work with the sheriffs as well. And that's my ruling as chair. So I'll see you next week.
Okay.